Hello everyone. Today I talked about important maritime law acts in Texas. Maritime injury cases and property damages cases are dealt with using a series of act and general maritime law principles that have been built up over many years. Legal principle governing the air to compensation and medical expenses for an offshore injury and jurisdiction for or claim are set out in these acts. Longshore and Harbor Workers Compensation Act. Longshore and Harbor Worker Compensation Act serve to compensate many different type of maritime employees. Some example of workers that can claim under this act include construction workers, longshore workers, dock workers, cargo workers, ships workers, uh, shipbuilders, etc. In order to make a compensation claim under this act for a maritime injury, the worker must demonstrate that they are a maritime worker and that their injury occurred on navigable waters or adjustment to such water including docks, piers, etc. Out Continental Shelf Land Act. The Outer Continental Shelf Land Act is an extension of the LHWCA. Workers who are injured on the outer continental shelf of the United States are entitled to make an injury claim under this act. They must show that their work was in relation to exploring and producing natural resources. If you work on an outer continental shelf oil rig, you may be entitled to file a maritime injury claim under this act. However, if you are employed by the US government, a foreign government, or a state government, you will be impacted for filling a personal injury claim under the Outer Continental Shelf Land Act. Death on the High Seas Act. All deaths that occur on the high seas outside of a state's territorial water are covered under the Death on the High Seas Act. This act provide that family members of workers and passengers who die due to an accident at shore caused by wrongful act, neglect, or default occurring on the high seas can bring a lawsuit. Family member can only recover compensation for pecuniary losses like financial support and will be unable to recover medical expenses and funeral costs, and the statute of limitation for bringing claims under this act, this is 3 years. Jones Act. The Jones Act, also known as the Merchant Maritime Act, was established in 1920 and covered the right of seamen to file claim against their employer of an offshore injury. Under the Jones Act, workers have a right to file a compensation claim against their employer if they were wholly or partially responsible for their injuries. As such, your employer only need to play a part in causing the personal injury you suffer to recover compensation. Some incidents of negligence covered under this act include failure to maintain and prove safe equipment for seamen, having knowledge of extreme weather condition and not taking steps to avoid them, knowingly giving negligent orders and instruction to workers, failing to provide medical treatment to injured workers, having knowledge and extreme weather condition and not taking step to avoid them, knowingly giving negligent order and instruction to workers, failing to provide medical treatment to injured worker. Injured seamen can make a personal injury claim against their employers for whole or partial negligence in a state of federal court. Workers also retain the right to a jury trial. To bring a claim under the Marine Act, you should speak with an experienced maritime lawyer who can help you with your claim. Claims under this act can often be complex, and a Texas lawyer can help gather evidence on your behalf, build a strong case, and ensure that you receive proper compensation for your injuries. Federal laws, as provided by Article by United States Constitution. As such, the federal court have jurisdiction over cases involving personal injury and damages to the property or navigable water. The only area that the state court may apply their own discretion is in relation to the compensation process for victim. Although federal law governs all maritime injuries, injured workers and seamen may be entitled to bring maritime claim in state and federal court in Houston. Injured maritime worker can bring a personal injury claim under the Jones Act in Texas state court, and offshore oil rig workers can also bring a federal law case to a state court. The crossover between state and federal maritime law can be confusing, and often workers are unsure whether they can bring a claim to a Texas state court. One of the maritime lawyer from our law firm can offer you advice on your injury can a case and bring your case to a state to federal government. And this means that any body of water that allow trade between any state or foreign power is classified as navigable water. Currently, navigable water is defined as water that can act as a continued highway over which commerce is or may be carried on with other state or foreign countries. So, if a body of water enable trade or commerce with another state or a foreign country, it is governed by maritime law. Bodies of water that are part of greater navigable water will also be governed by maritime law, even if they do not directly connect to another state or water. As such, a body of water that is closed off by a larger piece of land or landlocked will be governed by state law rather than the federal maritime law. Maritime law is a group of law that are specific to maritime workers and their employer, as well as other companies and individuals that work out at sea. They govern what happened following oil platform accident, dredge accident, and cargo ship accident, as well as any other from an accident on navigable water, including at high sea. The high seas refer to any body of water that is beyond the normal territorial water of a country or a state. Maritime law also cover territorial water if it is located within 12 miles of the shore. As one of the oldest set of law in the United States, maritime law has changed a lot over the past 50 years. Originally, maritime law would only apply to victims who had suffered an accident while on the high sea. Thank you.